These fishermen are at the center of a Supreme Court case called Loper Bright Enterprises v. Raimondo, which involves a challenge against federal government fees.
They are challenging a federal agency rule that requires them to pay for onboard at-sea monitors. And the fishermen object to that interpretation of the statute and say the government doesn't have the power to force them to pay for the third-party monitors. But the case is really about the power of the federal government and federal agencies and who gets to decide when Congress passes an ambiguous, unclear statute, what that means, how it should be carried out, and what regulations should look like. So this case presents an opportunity for the court to revisit a 40-year-old precedent known as Chevron.
The 1984 decision in Chevron v. Natural Resource Defense Council set a precedent, which indicated that judges should defer to the reasonable interpretation of federal agency officials when administering ambiguous federal laws.
This has long been a target of conservatives who think that the federal government is filled with unaccountable bureaucrats who have too much power. They have urged the court to overturn Chevron.
Overturning Chevron is about restoring the constitutional allocation of powers between the three branches.
The case was brought by commercial fishermen, but they are represented by conservative legal organizations that have received millions of dollars from the billionaire Koch networks. It's perhaps not surprising that this is coming up now. It's part of the result of former President Trump remaking the judiciary and nominating 3 justices to the Supreme Court. But the Biden administration and others defenders of Chevron say the lower courts still really depend on this and thousands of decisions upholding regulations, and that the lower court should continue to be able to use Chevron deference. The court's being asked to take this big step and get rid of Chevron deference after 40 years, but it's possible that they do something short of that and either give new guidance and direction to the lower courts or chip away at Chevron but not toss it altogether. But these slender, silvery fish could end up having an outsized effect by weakening the power of federal government agencies to regulate vast areas of American life.